going to come throughout. So welcome to the next in Coram Chambers series of online webinars. Today we're going to be talking about a talkthrough of a remote FDR. My name is Adrian Barnett-Thoung-Holland. I predominantly practice in financial remedies. The first thing I just want to raise up is a few housekeeping, so to speak, things. If you are all able to, you should be able to pop out the chat on Zoom. If you go to the bottom right under the more tab, I think, or there's just a chat button at the bottom, and you'll see I've put a couple of links in there for all of you to look at. The first is the last blog post in my series on lawyers in lockdown. You can find the links to the previous two. I've been writing for the past number of weeks about the immediate experience of us as practitioners about this lockdown and how it's affected us. This one has just gone up and will be dealing and deals predominantly with the client experience, which is also something we're going to focus on today. So do have a read if you have the time and the opportunity to, because I think it's an issue a series of issues, I should say, that we all need to be dealing with right now. The second link is to Coram's YouTube channel. All of our webinars can be accessed from our YouTube channel. The recordings go up at the conclusion of these webinars. I can't recommend enough Amanda Bewley's recent webinar on identifying those who are at risk of suicide in family proceedings. The recording that you can find there at the Coram YouTube channel. And of course, don't forget to, if you can, like, subscribe and follow the Coram channel to receive live updates of all of our webinars. I've also included my email address, that won't be coming on the YouTube broadcast, obviously, in the chat, for those of you who may have questions following on from this talk, because I know that this is an issue whereby some of the things you might think about might not come up until you're actually conducting a remote FDR yourself. And I'm always willing to help anybody, any of you, out with any advice if you come up against a particular issue, whether it's technology, practical. So with that in mind, if you do have questions that arise as a product during my webinar today, feel free to put them in the chat. I won't be addressing them until the end because I think it can disrupt the flow for everybody. But obviously I'll be able to review those and we can talk if there is any specific concerns everybody has. So let's crack on, shall we? So today's talk is obviously entitled Talkthrough of Remote FDR. And I was thinking about the title last night and it occurred to me the walkthrough part's a bit of a redundant point to add, but I'm going to take you through what many of you are familiar with in many ways, an ordinary FDR day, but considering how a remote FDR is different from your usual fare and what you're used to. I'll talk a lot about technology, which is, I'm sure, something we all need to stay abreast on, and something that many of you have improved your familiarity if you were struggling previously. I should add, despite the title, a lot of the things I'm going to be talking about are also relevant to Children Act cases. So if you are a practitioner or have a mixed practice in both Children Act proceedings and in financial remedies work, a lot of my recommendations are going to be relevant to you. Now, I want to add two caveats before I start. The CFC's recent guidance, well, at the start of the lockdown, I should say, it's not all that recent, at the start of the crisis, was that FDRs were largely being adjourned or vacated. And I'm sure that's an experience that many of you have had, as it was being regarded as lower priority work. And the second point is that the feeling, if current trends continue, with further indications from the Central Family Court that they're moving to hybrid hearings, is that we might be back to in-person hearings maybe as early as July. Now, don't quote me on that. I don't know how soon, and I don't think any of us know how soon. But I want to respond with this for 2 points. If you're wondering why have a discussion about remote FDRs when there's a likelihood we could be going back to live in-person hearings, and the fact that there may not be many happening at the moment. There will still be remote FDRs taking place. Many of these were listed at the start of the lockdown. Many of you may have some to look forward to or ahead of you. And the second point, the more obvious point, is that we don't know when the lockdown easing will result in things going back to normal. So there may still be FDRs listed for remote hearings. It's also worthwhile to note that the skill sets that you can develop conducting remote FDRs may still be relevant in other aspects of your practice when, for example, you might be considering private FDRs, which could be conducted remotely. I think the thing we need to learn from this period is that we have all adapted, we have all learned skill sets that we can apply, and we shouldn't forget the relevance of those skill sets. Just because remote FDRs are not ideal in some senses, or the courts consider that in-person FDRs are preferable. It doesn't mean that we should unlearn all of the skill sets that have allowed us, for example, to have this webinar today, or to conduct the hearings we already have. There may be circumstances where remote hearings in both Children Act and financial remedies applications remain relevant, and knowing how to conduct those in the most efficient way is still going to be something that will help you. Above everything else, the COVID-19 crisis has taught us it never hurts to have a few more strings to our bow, a few more feathers in our caps, a few more metaphors about having further skills. But the relevance of that is that you shouldn't unlearn that which you've learned, and always and never rule out the possibility of conducting remote FDRs in the future, even after the crisis has passed. So let's look at the time frame and processes you need to be thinking about when you see a remote FDR listed. From a practitioner's perspective, the core preparation doesn't change. You would still need to consider the papers, you prepare submissions, isolate the matters at issue, consider offers. Most of those directions aren't hugely impacted, if at all, by the hearing moving to a remote space. Many of you will now, either prior to the crisis or presently, be very familiar with remote working, using digital documents as opposed to hard copy. That won't have changed, and FDRs in person or FDRs remotely won't change that. But the thing that we all are aware that dramatically changes any sort of family proceedings at the moment is the engagement with technology, which, as I said, all of us are doing right now. It comes across as an obvious point, but familiarize yourself with the technology. For example, there are a lot of commands available here on Zoom, a few I'm going to mention today, which are worthwhile knowing, because you may not have been aware that they can be used, or getting better familiarized with them helps you significantly. Using technology for many of us should be as simple as putting pen to paper. And as I said previously, we've already got used to that. But for those of you who are, the Zoom is still new, or much of the technology is still relevant, or scenarios where perhaps you've been used to the telephone remote hearings we've had for most of this period, but as the Central Family Court moves to hybrid hearings, you need to get familiarized with Skype, for example. Take the opportunity to test around, make a dummy call to a friend. Zoom allows you to set up your own personal meeting, which you can play around with the various commands that are available to you. So try to do all of that and make sure that you understand the material in front of you and the technology you're going to be using. Small things like that people I often find miss is some software automatically mutes you and doesn't enable your camera from the start. If you hadn't checked that beforehand, you'll undoubtedly be flustered in a hearing or in a conference with a client when you haven't taken the time to do that. One of the things that I did want to touch on in terms of preparation and working is this point about multi-screens, which has been talked about, but I don't think hugely well explained. It may sound self-explanatory, but I know that there are a lot of people who are still getting used to much of the change in technology, and I do want to always extend a helping hand to them. Now, two screens is essentially using two screens, but one partially because you need to have a separate screen to deal with, as we have here, the visual aids of conducting, for example, a video hearing. Most people rely on using laptops at the moment. A second device such as an iPad, preferably not your smartphone, can be used to have the bundle in one and then documents and the call in the other. That's a very simple fix to apply, and for those of you who are predominantly paperless working, you will have probably built that into your working habits already. For me, this is my desktop setup. I have two screens, an independent webcam, and a headset you can obviously see me wearing. But this is a fairly high level setup. You don't need to be at this stage. Most of your laptops have inbuilt webcams, as I'm sure all of you are probably experiencing right now. But as I said, understand the technology, understand how you work and how you operate. I still see some people who are working from one screen who are still taking handwritten notes. Do what works for you. Integrate the technology into your working habits and your preparation. Don't fight the technology into your working habits and preparation. Because your digital workspace is just as important as your physical workspace, but it also is personal to you, as we all know about our physical workspace. Small other technology points that I'm going to touch upon very briefly. Internet strength in video hearings is often reported with cutouts and people having difficulties when they lose wireless signal. I assume the majority of you are using wireless signal. If you are you need access to your PDF papers prior to a hearing, download those first, save them in a secure place, and make sure those are open before the hearing. If you download them during the hearing, you may cut out if you're relying on wireless, because your wireless bandwidth, that's the amount of information that your internet processes to your computer at any one time, may be compromised. So make sure that you don't need to download anything. The only use of your wireless internet should be the video conferencing for the hearing or with the client that you're involved in, just to stop stuttering, loss of signal. Ideally, you would want to be plugged in directly to your wireless router. I know that's not always the case because people are working on laptops. They need to be able to work in different parts of their home, different environments. It's more convenient to have Wi-Fi. That's fine. But make sure you're not consuming the bandwidth. And it can be little things like you're having a video hearing and somebody's Netflix on the TV or Netflix on the device in the next room. Make sure that you test and make sure that video conferencing app software is still operable when others are on the internet as well. It's a small point. The likelihood that someone will turn on Netflix on their device in the next room and your entire wireless connection will go down is so remote that it's probably not risking. But at the same time, be aware that use of other devices on your Wi-Fi could impact your signal strength for video hearings. And nobody wants to cut out or end up stuttering or losing image in the middle of a significant piece of evidence during a video hearing. Just going quickly back, and you've probably all heard this a lot, and it's been discussed a lot, and you have all obviously observed it, muting microphones during hearings. You've all managed to do this, obviously, as I can see that, but little things like knowing the fast controls, if you've only got one hand free because you're taking a note or you're working on another document, knowing the fast controls and the shortcuts can help you a great deal in making sure that you can efficiently mute a mic, cut the screen, whatever. So for example, I'm not going to ask you to test this now, but I can just demonstrate it. The mute button, you all know where it is, but the mute hotkey is holding down Alt on your key A. So I can alternate mute myself whenever I need to at the touch of a couple of buttons. It might seem like a small thing, but that can save a lot. That can be seconds quicker than just clicking on it with your mouse. Small things like that. Small things like Alt-H will close and open the chat window. These things save you time. And as I said before, this is about making the technology work for you. Now, you may take the view, well, that doesn't save me that much time at all. Fine. But knowing that you have those facilities available to instantly mute, instantly close your camera, instantly open and close a chat when you need to, these things can really help you. So always, always take the time to learn and understand the technology you're using. This isn't just a specific FDR point, it's a general point in the current environment we are, because the more familiar you are now, if Zoom becomes used for remote hearings a year from now, you've already got the advantage of that knowledge. So don't forget it as well. Get as proficient as you can. Now, going back to the preparation stage, one of the things for an FDR, one of the things I am very keen on in both financial remedies proceedings and Children Act proceedings is early conferences. We're all familiar with turning up to court and meeting client beforehand, having had no direct contact of any kind. I think in the current environment, there is a huge onus on making sure your ducks are in a row before you even get called into a hearing or even the day of the hearing. If you can, that is the caveat, if you can, organize an opportunity to speak with your client if you're the advocate for the hearing and you haven't met them before. If you're solicitor preparing the papers, you likely will have spoken to the client before, but it may be useful to sit in on a conference with counsel or the advocate and the client as well. They don't have the opportunity to see you in person beforehand. They don't have the time to get used to you. Telephone communications, unlike court days, are comparatively shorter. So make sure, if you can, as I said, that you have the opportunity for your advocate to have a discussion with the client beforehand, so they get just used to how they're working. This is to make up for that space, and some of you may have seen it mentioned in my blog. That is to make up for the space that we don't have at the moment of face-to-face human contact. I would even emphasize that can be done with video conferencing facilities, just to see each other and see the other person. So much the better. It is just one of those things that we've ended up with because the client time in the period between an hour before the hearing to the hearing has been lost, and I'll explain why in a moment. The earlier conference is just to get that touch base and get the client familiar. It can be used to take instructions if there are significant issues that as yet you haven't had the chance to take instructions on. But I think it's more important as an opportunity to get to know the advocate, because that's hugely important, as you all know, for the client to build that rapport. Its second function is about this aspect of engagement. Now, my recent blog, I've linked it in the chat, refers to the Nuffield Family Justice Observatory report, which was conducted in April. I really cannot stress enough you read it, particularly with the recent BBC story that's just dropped about the so-called cruelty of remote hearings. It paints a good light on what the issues were identified with remote hearings. And one of them, in my view, is about engagement and involvement. Lay clients are consumers of the court system as well. Our biggest role at the preparation stage is engaging them. By meeting their advocate earlier, they can feel more involved in the process rather than just hearing somebody else talking about their case without direct involvement from them. As I said, it's also necessary to create that human contact we don't have at the moment. And I would always stress, if you are either an advocate yourself or you are instructing advocates for hearings, to make sure that they maintain a higher, I would say a higher level of communication with the client than they ordinarily would. The thing that's brought this on is because, for some reason, remote hearings in many places have turned to this is an X o'clock appointment, which is interesting because that's often lay clients' expectations. But from experience, we know that not to be the case. Cases are not called on bang on the time we're told to be there. Cases do not start when they're supposed to. Sometimes you need more time outside of court for discussions. The courts, in my experience at the moment, using the telephone remote hearings, are just calling you at the time of the hearing. That actually minimizes the control you have over your hearing time. And this is more relevant in an FDR scenario because, of course, negotiation is a larger, if not the largest, part of an FDR. You are under the pressure of the clock. You can't take an extra half hour, an extra hour, depending on the judge. Obviously, some judges may be more willing to do that, but they will have lists where they are committed to times. So that client engagement with the early conference really buys you back time you will lose, because that hour before hearing, when it's actually an hour in a hotly contested case with significant issues, it runs out very quickly if you're spending time taking instructions and then having to ring for discussions and then eventually get called by the court. So read that report and take into account these issues about engagement and ensure that your client is really kept up to date about how the hearing is going to take place. There's been a very helpful recent resolution document, I understand, that was designed for litigants in person, which is a very good primer for lay clients that you are representing to just explain this is a checklist of all the things that will help you out. I still think that doesn't replace talking them through it so they understand it, but that's a good starting point if you want to look at the issues that you might want to raise with the client prior to a hearing. Those of you who may have considered my last blog, not the recent one that I've posted, but the one previous about a complete reportage of a remote day at court, is I'm conscious about understanding the client's circumstances at the time of the remote hearing. All of you undoubtedly have thought about this and taken it into account. But just to reiterate the point, unlike an in-person hearing where we know where the client is, we know that they're available and at court, and more importantly, if you're doing a Children Act case or there are children in your financial remedies case, we know that the children are at school or have alternative carers with them. We know their circumstances. We don't on a remote hearing. We don't immediately know them. Some of the content of the report that I've just directed to you was frightening in that parties were being engaged with proceedings in sheds, at the roadside, and one particular reportage which concerned me significantly in a child protection case was that a parent was involved in a hearing from the car outside the hospital where the subject child had just been born. That is, I'm not going to say it's preventable, that's not the word I mean, but the earlier you can be aware of your client's circumstances, the better. The obvious one for those of you practicing children proceedings is, of course, where the children are at home, which has been the majority case for many of us. Some clients have asked me, can I not attend the hearing because there's no way I can find a private space? If it's a small issue hearing or there aren't many contested issues, provided you obtain the court's permission beforehand as you ordinarily would do, that's not a problem. The court will understand. But account for and explore how the client can be involved with the hearing. Some people are not able to find a private space, and I am curious for clients how easy it would be to find a space away from children, particularly when there may not be another adult in the house to supervise them. Examine and adapt your communication methods with the client as suits them. Some video communication for a conference may not be suitable because of disruption of children. It may be easier via telephone because most people, and the accessibility problem goes away. You can communicate with nearly everybody via telephone, but sometimes parties do not own telephones, don't have any credit. We need to account for all of these things. And similarly, as I mentioned before, just as you should be as familiar with the software as possible, so you should be able to assist the client as far as possible with the software. We have been forced to adapt. We have got used to it. Many people have had no reason, even during the lockdown, to engage with a lot of the technology. Some of it has been new to us as well. Take that time to understand the client's circumstances and work out a system and an approach that can work for either attendance at an early conference or attendance at the hearing. And most importantly, update the court on it. Because I am seeing, and I have heard numerous anecdotes and stories of courts being genuinely surprised about parties' circumstances, even in cases where the children are present with a party at home during the lockdown. Keep the court informed, and I can't guarantee you what they're going to do, what they'll be able to do, but it needs to be made clear because it should not be something that comes up in the middle of a hearing. With an FDR, this becomes doubly important because you have to have a larger amount of communication with both other parties and clients. So I would really stress that in your preparation stage. Find out the circumstances, adapt to those circumstances. There will not be perfect answers to every situation. But even as simple as, well, I think I might be available at this time because the children will be asleep. Use what resources that are available that suit the client. We need to promote this engagement for them. As I said, FDR's even a greater example because this is a client-led negotiation and it's so important that they can remain engaged. One extreme example, and I'm not sure that this is being taken on by many solicitors, was that counsel, solicitor, and the lay client attended at solicitors' offices, I believe because the lay client didn't have the facilities at the time to engage in a video hearing by way of social distancing. I'm not suggesting that is the best way, but as far as I can see, that seemed an appropriate way. It didn't disrupt anything. I don't know if it made it easier for the other side who were conducting this, but that's one example of how far you can go within reason, within the limits of government guidance, to effectively conduct a hearing for your client's benefit. Extending to that is how representatives communicate. Now, if you're a solicitor performing your own advocacy, you will obviously have the advantage of having had the correspondence prior, so you know who you're talking to and will have had communications. If you both instructed counsel who are newly involved on the case after you've had this initial conference, it's sensible to make sure that you exchange detail about counsel so that counsel can communicate with each other about when to conduct discussions and negotiation. I know that happens in a lot of cases, even in person, but it's hugely helpful as a barrister when you're attending an FDR to have contact details for your opponent as well as for your solicitor and your client, because they're the other person you're going to be talking to the most. If you are counsel, make sure you secure those and drop an email to your opponent. If they have a public email, it might be easier, but you need to know who they are because you want to take into account, again, are their circumstances? When are they going to have time to have discussions with you? And then almost agenderize it. Well, if I've spoken to the client ahead of the FDR, on the day of the FDR, I have the opportunity to speak a little bit earlier to my opponent, then an opportunity to go back to my client, build that in before our court appointment at 10:30, 11. Break that time down in a way you wouldn't ordinarily. This has happened because, as I said before, the courts are saying this is the time of the appointment, this is when you're going to be called by the judge. How often does that happen to those of us who regularly attend courts? Very rarely at FDR stage because you're in a lot more control of the judge. The judges are now quickly telling you, well, you're going to have an indication at this time. We all know, most of you who do financial remedies proceedings will know that sometimes an early indication is vitally important to the case, and sometimes it is detrimental to any negotiations you've got on with. So use and buy all the time. And if that means that the representatives are having the longer discussions or contacting each other earlier than an hour before the hearing. I can see that only as an enormous benefit to getting the case going forward, particularly if you're, as you should always be, focusing on trying to reach a settlement. It may be that there are some cases whereby, well, we're too far apart, we're not going to get anywhere, but at least you both know that. Again, applies in Children Act proceedings as well. We always need that information as soon as we possibly can. It would be helpful always to use that hour before for, if there is intense negotiation, for that to happen. And that can be minimized and used maximally, I should say, if you ensure earlier engagement with the client and then buys you some time back just for negotiation. One thing that is also worthwhile setting up and organizing, and I know that this will be something that comes to the forefront of many of you, is how about my client having discussions with me during the hearing? This is an issue that's been bothering me recently, the more I've thought about it, and I'll explain why. Throughout the remote hearings, which I'm sure many of you have conducted, we have replicated the in-person experience: conference, discussions, court, order, subsequent aftercare. The process of taking instructions during a hearing is a critical process which allows us to be flexible and to respond to points that may not have been discussed. Often it's because the judge has raised a point that nobody had the opportunity to discuss. Why is this something that is not happening in courts? I find it surprising and bemusing where we're trying to replicate the same experience we always have, and then all of a sudden this one critical point is being left out. My attempts to encourage the court to allow us to leave the call and then come back and go dialed back in have had mixed responses. Some judges take parties directly addressing them, which I'm not sure I'm always comfortable about, because I'm not sure what my client is going to say in a lot of these situations. Try to work out a system with your client, again, that suits them, that's capable for them, and is accessible for everyone, that allows them to give instructions to you during a hearing. The methods have been variously offered. Emails is possible, emails via instructing solicitors, WhatsApp in the extreme scenario, but bearing in mind there are some clients you don't want having your personal details, and WhatsApp isn't always secure. That's not ideal. Text messages during the call can be problematic, because although a lot of smartphones are more than capable of allowing you to keep the call on speaker whilst answering a text message, you're using the same device to do everything. My first instance would always be to say, well, Judge, we need to have time to take instructions on that issue. Again, this stricture about timings that suddenly has come out of nowhere in terms of the courts is often refused. I don't like the idea always of my client being addressed directly or addressing the court directly, unless it's a very basic issue, which is a yes or no answer, and that won't result in huge amounts of problems. But then can we always know that? As I said, there's no right answer to this one, but find a way to be able to take instructions and discussions during a hearing and discuss that with your advocate, with your client. Make sure everybody knows how that's going to work. Still on the point of preparation about uses for technology, one of the things that I'm going to show you and talk about is how to use software like screen sharing. Now, I dream of the day where we're able to conduct remote trials like this that actually work, but we can actually also share documents. So what I'm going to do, if you look at the bottom tab when you highlight the window, you see the screen share option. Some of you may have used this, some of you may not be familiar with it. I'm just going to click on the screen share option and show you a document. This is just a mock-up document. This is a test dummy asset schedule. One of the things you can use this material for, if you're able to use videos conferencing, is you'll see these numbers I've created at the bottom. I can use this spreadsheet of my asset schedule to show, in this particular imaginary instance, divisions of the proceeds of sale, so that the client can see those figures in front of them, something you don't always have the advantage for, if at all, on a telephone hearing. So for example, we've got the 5347, we've got 7228. These are just, it's a small thing, but it's an easy thing. Many people find it easier to visualize something than rather to be told figures about it. And inevitably what you'll find is that clients will be told the figure, then write it down anyway to visualize it. So be aware that, of course, these sorts of tools are useful in conferences in preparation beforehand, because you have the opportunity, for example, going through an order, going through a note, going through an asset schedule with a client on a video conference beforehand, you can physically take them through it rather than just telling them what you see in front of them. How many times have we been reading out the content of orders to clients after the hearing's completed? As I said, getting into a dummy call with Zoom or Skype with a colleague and testing out all the functionalities, really great way to make yourself more familiar if you haven't taken that opportunity already. The last point I'm going to say about preparation is something that we are all familiar with and probably is the most familiar with, and that is the setting up of a hearing. The telephone hearings obviously will require our phone numbers. Reminder for those of you that work in Central Family Court, they are requiring email addresses to set up these hybrid hearings that also involve video conferencing. So if you are looking forward to a hearing at the Central Family Court in the coming weeks, make sure you're providing those details and those of representatives, counsel of parties as well. It will still be the case that many of these hearings will be conducted by telephone. And I know that I've been bent very much on video conferencing because that's the preferable direction for us. But be aware that, of course, telephone hearings are still going to take place because either some courts lack the resources or some courts will just be slow to change. The Central Family Court is a decent bet of moving the fastest compared to other courts. So while I know it can be a lot of hard work, make sure you've got those all set up at the court's insistence and ready to go. Generally not encountered many problems with that. Obviously, the simple problems of courts losing details not getting through. I did have an interesting hearing, I think a few weeks ago, when the O2 network went down and both myself and my client didn't have accessible numbers to be contacted on by the court. But fortunately, the network came back up in time for the hearing. Account for all these things, but make sure you're providing all the information in advance. And there have been some instances where, particularly with FDRs, because courts are in a position where they're not that keen to list them, is that they put the onus on you as the applicant or as a representative if the applicant's not represented to organize hearings yourselves. So again, one, supports my point about getting used to the software and the technology, but also finding a preferable service for conference calling, telephone, video phone conferencing, which suits you, can help you with that and then organize it in advance. But get your ducks in a row. It's more important. Because with physical hearings, everyone just needs to be at court. We'll work out the rest, we often say. But with technology being relied upon in these remote hearings, there's more onus on the time spent getting everything ready, not just bundles and notes and offers, but also the practice of being able to conduct the hearing in the first place. Assume you need to help the court as much as possible, and you won't go far wrong when setting up a remote FDR. So that's the preparation stage, and you're already undoubtedly aware there's a lot there that needs to start being, when the cogs need to be turning. And if those of you have remote FDRs that are going to be conducted remotely in future, in the coming weeks, make sure you're thinking about those things as early as now if you have the opportunity to. It doesn't take long to just make a checklist and just go through, right, this is what I need to be looking at if it hasn't been dealt with already. Or if you're not the person who needs to be looking at that, make sure that somebody else is. If the other side need to organize the call, if the other side need to organize the bundles, as you ordinarily would do. The preparation time for remote hearings is higher because we just don't have the advantage of being physically present at the court. I should finally add, just on the preparation section, is a lot of those elements may still apply were you to be looking at alternative dispute resolution or private FDRs. In fact, they're exactly the same in terms of preparation for those cases, and they would be ordinarily live hearings. But you do have the advantage that the so-called court in a private FDR or arbitration or mediation, you can communicate with about the mediums that they prefer to use. So you have them assisting you rather than limiting you, as often is the case with some remote courts at the moment. I'm going to move on then to the meat of this, which is, of course, the hearing day itself. Now, I mentioned before that I am still suspicious and curious about this practice of us just replicating ordinary FDRs in a remote setting. It certainly makes a lot of sense if you think about it, because we all know what to expect. We all know the processes we've been doing, many of us, for many years, about how these hearings take place. We also know that no FDR is the same. That some days you turn up in the morning and you've agreed because somebody's conceded, or other days you're negotiating hard until the end of the day and you still don't get anywhere and you're drafting directions. So just as you are looking at this is how we ordinarily do it, remember that there's not a this is how we ordinarily do it with FDRs. We all know that. and be flexible and be prepared in some ways for a longer court day in a different sort of sense. Obviously, you need to make sure everybody's got each other's details for the purpose of discussions. I mentioned that before. This includes litigants in person, because of course they're no less they're not robbed of the opportunity to have discussions in the same way you normally would at an FDR. Experience tells me in financial remedies proceedings and children act proceedings at the moment, litigants in person are far less keen to have a discussion with you prior to a hearing, because I'm actually about to say because, and I'm not sure why. They still have the opportunity. You still need to speak to them about the issues. But just be aware that litigants in person, in my experience, I could be wrong, and someone's undoubtedly going to point out a litigant in person who is extremely chatty in discussions, I'm sure, and also in court. But just be aware that litigants in person will find the proceedings more alien because nobody's prepared them in advance for it. Be aware of that. Be accommodating as far as you can, because of course they have the opportunity to have discussions at an FDR. Put your offers to them, have those discussions, and ensure that everybody knows the timings of that, which is my next point. You don't have, and I've said this a few times, you don't have the luxury of knowing that you have time on your side or against you, as the case may be. You need to structure the time outside court more now. Again, a point for Children Act proceedings as well. If the court would ordinarily expect attendance at 10, let's say for an 11 o'clock hearing, would you say to the litigant person or the other representative on the other side, well, let's call at 10:30, 10 o'clock, if you've already had that initial conference and you don't have any further instructions, quarter past. How long is this going to take? Sometimes it's barely any discussion. We can't agree, too far apart. Sometimes it's that back and forth. And then, of course, if you do get forced into court, called into court, obviously you'd need to be off the phones around the time the hearing is, because courts are fairly efficient about calling you into a hearing. But structure the time. With any of your remote hearings at the moment, if you are having discussions of any type, structure the time and lay it out and make sure that everybody knows to be available at any given time, particularly between representatives at court. Agreeing modes of communication helps. Sometimes some opponents will say, I'd rather do it by email because there's not really much to discuss. Others generally will expect you to call them. Who's calling who? When? How? Have you got an indication to tell the other side that actually I'm still in discussions at the moment if you've overrun? This is more organic and more fluid in in-person hearings, because you can easily just walk around to their conference room or the public waiting area and say, well, okay, come back in 5. It seems more arduous, of course, to dial in a number and make that phone call. Structure at least everything before the hearing itself, the indication itself. Lay it out so that everybody knows what to expect. And if there are deviations, at least you have something to fall back on and look to and be prepared to, because the courts are, as I said, being more militant about when hearings are starting. That's really important if you want to maximize your time for negotiation and discussion, because you will run out of it if you take the ordinary approach of being in person, just ring whenever or just expect a call. The amount of time you spend at a remote FDR sitting around not knowing what to do because you're waiting on somebody to get back to you about something, when you should have said, look, if I don't hear from you at this time, I'll call you, or email me and let me know you're still discussing. Keep the lines of communication open. And I would say explore all the lines of communication as you would with a client. Emails, I've been on a phone call with emails open, texting back to my client and receiving communications all at the same time. Yes, you'll feel like a bit of an octopus and multitasking is going to be a challenge, but at least you're maximizing the resources available to you to perform your task and do your job. During hearings, the usual courtesy elements apply, muting microphones, which has been, I think, one of the most mentioned parts of many of these discussions on remote hearings. I want to reiterate that in a different way. There are firstly, of course, the hearing's being recorded, and you don't really want the noise of you beating your keyboard to death on the recording of the hearing. But also, I find that there's a tendency on telephone hearings for people to go on speakerphone, which then picks up more sound. It's one thing to be sat in a courtroom with someone tapping away at a keyboard. It's another thing completely when the speakerphone is sat next to the keyboard and it's amplifying it. I'm sure all of you, or most of you, will have a story of an opponent who you are praying to make a submission in court because then they will stop typing on their keyboard. mute your microphones. Don't use speakerphone either. I don't think that's a good idea, simply on the basis that even if you're in a secure space, you're broadcasting the hearing around you. That doesn't stop others wherever in your household listening in or hearing things. Don't use speakerphone. If you are in a secure place and you can be sure that you can't be heard, you can use speakerphone to get both hands back to type, make notes, fine. But I also think the microphones, speakerphones are not ideal either. So if you're giving submissions, don't be shouting at your phone on your desk. Hold the phone up to your head. Only if you can then hear what's being said. It can be a pain and very difficult to be holding a phone to your head for an hour, or alternatively use I won't say AirPods. I think I mean AirPods. Headphones with press mics in the headphones. That's not ideal either. But at least the advantage of that is you won't have to end up putting up on speakerphone. Work out procedures that allow you to take part in a hearing and conduct the hearing with consideration for privacy, confidentiality, engagement, and making sure that you can still do your job. And being able to do your job can be dramatically affected by the background sound of children, which can be quite distressing for the client as well, or for the other party within the children are not placed, and can also be exceedingly distracting if there are just background sounds. Even things as simple as sitting by an open window and traffic in the background can make huge differences. So just be aware of your own surroundings. I'm gonna just, my personal view, if you are on a video conferencing app, dress like you're at court. I'm clearly wearing a tie. I take the view that I have to be dressed as I would be at court, and I like wearing ties. So I think you should always be dressed as if you're at court completely. I won't make any mention about whether you're just dressing the top upwards or not, just what can be seen. And also, we have obviously the benefit of putting these lovely green screen sort of Coram backgrounds on ours. Be aware of what else is in the picture. I'm not suggesting that anybody has anything racy or compromising in their backgrounds in their offices. I do hope you don't. But even then, distracting art, pictures, things that are perhaps more interesting than you might be in a video hearing, don't have those in eyeline. The advantage of Zoom is you can put these backgrounds up. I'm a big fan of them and have used them before in my video hearings. I perhaps may not prefer the shining white background, but of course we have the color scheme can be reversed as well. Think about that as well. I don't want to be blinding anyone during my submissions unless they're awful. A point that I've talked about before in previous blog posts, which I want to deal with very briefly because I don't think there's a right answer to this. Your advocacy in telephone hearings particularly may be different. How different is up to you, but I would invite you all during an FDR or any type of hearing, when you're performing your advocacy, have a think long and hard beforehand about whether or not telephone medium is actually going to affect what you're saying. I have found some people are briefer. I have found some people are longer. I find that in video conferencing, it doesn't seem to be that different. I could be wrong there, but think about your telephone, not so your manner, but how you perform your advocacy and how you get your points across, because silences are bigger in telephone hearings, I found, because you have no touch point to the judge or even your opponent or your client whenever you make submissions. So be aware of that. If you are someone who likes to make every point clear, then you may not find any change. If you're someone who likes to brief, you may find yourself extending your advocacy. Think about, more than ever, think about what you're saying and how you're saying it, because that can make a huge difference in a telephone hearing. And try to account for the fact that silence is going to be a component of telephone hearings, because that silence is bigger and more challenging. I find, just briefly ending with the court day point, traditional FDR days are in some ways less straining because you're at court, you're in the moment, you're having discussions, you're going to court, you're talking to your client. When you're here in a space like I am today, I'm sure that's the case for many of you, on your own, for several hours, waiting for a call, not sure when you can leave because you might get a call any minute, you might get called back into court any minute, and you need to rush off. How far is your office on the top floor of the house and the kitchen's downstairs? These are things that you need to think about, and it's exhausting when you have a very long FDR day, because actually, in some ways, there's less, I think the visual stimulus of being engaged drains out because you're in the same place. And many of you, I'm sure, have been in workspaces that you have been in since the lockdown. I know I certainly have been. Be aware of that. People are keener to get orders drafted immediately than they might ordinarily be. People are far more enthusiastic to get it done at that point in the day. And that leads me on to my next point, which I think is really the hidden point of all of this. The most important thing to think about when you are conducting a remote FDR from home is your own well-being throughout that process. We all know they're long days. Now magnify that by putting it a long day in your one space, staring at a computer screen, picking up phone calls or on a video conferencing software for that entire duration. Family law is an exercise in human drama, but you are also a component of that human drama. The challenge for all of us is that we are supposed to remain disconnected from that drama. But that can affect your well-being in the long term. When you can get breaks to get out of your office, take breaks to get out of your office. Lunch period is an excellent opportunity. Or, for example, you have made an offer to the other side. They're going to take it back. You have 5 minutes to have a walk and a 2-second chat with anybody else in your household. Those of you who read my second blog will note that I spent an entire day having not spoken to anybody in my household due to how it worked out. That is not what you should be doing if there's anybody else around, which there ordinarily would be. Get up instead of staying in a sitting position, even if that's still inside your own workspace. There's no harm in conducting negotiations or a court hearing while pacing your office to get your legs stretched out. And that sounds like a really silly thing, I know, but observing that will allow you to meet the stamina of a long court day where you are just sat in one space. Take a 5-minute break or so on the hour, just to clear your head. Get out of your workspace for a period. In terms of screens and technology, yes, we're using plenty of it. You may have now dozens of screens after we've talked about multi-screen setups. The health guidance I've been reading up on is 20-20-20, which is every 20 seconds, look at something 20 feet away for 20 seconds, look at something 20 feet away every 20 minutes. That will prevent eye strain and will also stop, again, that feeling of exhaustion that will come up from just staring at these backlights all the time. Just be conscious about ensuring your own well-being is being protected in these court days, particularly in long hearings like FDRs, where if we look at the entire process, I think everybody can name an FDR that went on to 6 o'clock or, God forbid, later. Everyone can also name an FDR that happily settled at the beginning, but the long-haul ones are the ones you need to be more aware of. Straightforward things, like remembering to keep your nutrition up, water, food. I generally don't like eating in my workspace because you just never leave mentally. Go and eat with others in your household. Go outside and make sure that you've got some break in your day. Because an FDR is an intense exercise of waiting. It's an intense exercise of formulating offers, clients who are in high stress environments that need your support and need you to be able to give up that time and your own emotional stability. But no one's looking after you in the same way you're looking after your client after the hearing's over or in the long waits between. So I'd really encourage all of you, when you are faced with an FDR that you perceive could be a long day, and to be fair, can we ever judge if they're going to be long days? Because of the back and forth, because you've lost all of that time of just being in a conference room with your client, being able to talk to them about the case and stay engaged. If you are in a workspace where you are going to be alone for a long period of time, make sure you're giving yourself regular breaks and make sure you're looking after yourself. Do not, as I have unadvisedly done, take multiple FDRs consecutively in the same week in this current environment. That is not going to do you any favors if you are jumping out of one to jump into the preparing the next one and going through, as I mentioned at the beginning, the whole checklist of things that you need to consider when preparing a hearing. So I know I've talked about a lot of things in somewhat of a disjointed way, and it's partially to do with the process itself is quite disjointed, but I'm going to give you some summary points for you to all think about. Set up the ground rules and technology early, get familiar with it, get your client understanding what the procedure is, but at the same time, make sure that you are taking approaches and procedures that are convenient and suitable for the client in their own circumstances, more so than you would do with a physical hearing. Early conference if you can. It saves time in the long run. It gains back time in the long run, which you now have lost because remote hearings and remote FDRs are giving you indications bang at this time. If there was actually some scope for you to have some conversations before the hearing takes place between advocates, I don't think that's always going to happen. But don't get locked into the belief that, oh, well, if we replicate what's happening in ordinary hearings, it will be fine. You need to be adjustable. Get an early conference in, get your client meeting your advocate and talking through the case. That buys back time for negotiations before the FDR. If it's an afternoon FDR, you could also possibly do that earlier in the morning as a last resort. As I said, if possible. Not all clients are permanently available all the time for further talks, and some clients won't mind so much that they're just having their advocate available on the day. Structure the FDR day. At least everything towards the indication period of the hearing. Lay out when you're going to take instructions, lay out when you're going to have discussions, and communicate that with the other side. Everybody must be reading on the same sheet of paper to ensure the smoothest possible running of the day. Big point next from me, think about mechanisms for discussions in court, because this one has been hugely discussed. There doesn't seem to be a perfect answer. There doesn't seem to be a perfect resolution of all of the issues. But make sure that you know an approach that's agreed with your client that you're all capable of working together on, so that if an issue comes up during the hearing, the client could communicate that to the advocate. Don't forget your mute buttons in hearings. Don't beat your keyboards to death with your mute buttons off. Think about things like speakerphone, headphones. Think about the hardware of your engagement with the hearing. Next, the point I made at the beginning. I know that the preference will always be for FDRs in person. I do have to agree with that, but don't rule out, after you come away from today, don't rule out the possibility that the remote FDRs are an option for you. They are things that are available to you and things that you should think about deploying. Clients abroad, clients unavailable. This applies to Children Act proceedings as well. What we should learn above all else from this is that we can't rule out remote hearings. And if the chips are down and it's the only alternative, consider it and think about how they can be done. Don't forget everything you've learned in this time already. And finally, perhaps the most important point, on long FDR days, think about your well-being and think about how you're going to manage that, because it is an exhausting process. It's exhausting for the client as well. And you will have spent, undoubtedly, your energy reassuring and helping your client through the FDR day. But think about what it's like at the same time for yourself, being locked up in one space and having to process the case with the uncertainty and the isolation that comes with it. That applies to every remote hearing of any given length at the present time. And I think I'll wrap up the substantive part of the talk there. As I said, the chat is open on the side, and I can see everything that anyone would like to post. If you have any questions now, I'd like to give you an opportunity to raise anything specific that you'd like to ask. If not, you can also see in the chat my email address. So if you have a remote FDR in the coming weeks and a specific issue arises that may not have been dealt with in my talk, or it's an unusual issue, do feel free to contact me via email and ask if there's any suggestions I might have, because I think the more we can learn from each other's experiences, the better we can provide a service that accounts for remote hearings whenever we need them, however we need them, and in what circumstances. So thank you very much for listening to me. So now it's over to you.